The committee will come to order. The gentleman from South Carolina, Mr. Timmons, is now recognized for 5 minutes.
Thank you, Madam Chair, and thank you to the witnesses for being here today. Commissioner Peirce, in the interest of time, please do your best to answer the following questions in a yes-no format. To your knowledge, does the SEC generally consider the sale of physical art at an art gallery or auction house a transaction of a security?
No.
Thank you for that. Does the fact that art collectors may be purchasing pieces of art at a gallery or auction house with the expectation that the art may go up in value change anything in that analysis?
No.
Great. Now, putting aside art galleries and auction houses, does the SEC generally consider the sale of physical art on an online marketplace like eBay or Etsy a securities transaction?
No.
Okay, thank you. I do not understand is how the SEC appears to be taking the stance that NFTs, these pieces of digital art and collectibles, are themselves securities, or that sales of them via online marketplaces constitute a security transaction. The only difference I see is that one asset is tokenized and the other is not. In the example of physical art that we just discussed, there are indeed many collectors who purchase art with the intent to profit, and artists who market themselves and their work in order to develop an ecosystem of patrons. So I fail to grasp the difference here. Is tokenization enough to transform a non-security into a security?
Again, the facts and circumstances of any transaction are relevant, but you put your finger on something that's troubled me, which is that we seem to be treating digital assets differently than we treat physical assets, and I think that's problematic.
Well, what exactly is the differentiating factor?
We have moved away from, so when we look at digital assets, we're saying they're being sold as part of a securities transaction because there's an investment contract associated with it. Yet pinning down what exactly that investment contract has been, for me, very problematic. It's based on statements, any statement about something having value, or a statement made by one of the investors that something might go up in value. And as you pointed out, you can have an investor who buys a piece of art. You can have a person who buys a piece of art and she expects that piece of art to rise in value, but we don't change that piece of art into a security because she expects it to go up in value. And it seems to me that we're doing that on the crypto side, and it doesn't make sense to me because I don't see the parallel on the physical side.
Thank you for that. I'm concerned that this is just an extremely slippery slope. If the SEC takes a position that most NFTs are sold as securities, where does it end? The SEC hasn't been able to articulate a limiting principle here because there isn't one. The view threatens not just crypto, but many other industries as well. And at this pace, the SEC's actions threaten to swallow large parts of the collectibles markets, the luxury goods market, musicians and artists of all types, and even the restaurant and events industry. Beyond that, the Commission is stifling blockchain technology as a whole, and it appears Gary Gensler is doing so intentionally. Commissioners Ueda and Peirce, your recent dissent related to NFTs stated that, quote, the NFTs here are utility tokens, not securities, and statements by the founders and NFT purchasers that a successful restaurant would cause the NFT price to rise do not change that. So, Commissioners Peirce and Ueda, in your dissent, you two also aptly state that, quote, the intent of a buyer cannot transform a non-security into a security, end quote. I'd like each of you to discuss the following questions. In your view, why has the SEC not provided clarity to the treatment of NFTs, and how could the Commission approach this differently? Commissioner Ueda?
We identified what is my primary concern. There is no limiting principle based on what you might discern from the Commission's enforcement actions. I have strong reservations whether that's consistent with the law. I mean, we've talked about the Howey test, but the Howey test gets implemented by the courts of appeal. So for instance, in the Ninth Circuit, there's a case called Glenn Turner Enterprises, which said that there needs to be such essential managerial efforts that lead directly to the success or failure of the enterprise. And in many of these cases, the artist just creates it, it exists. There is no subsequent managerial or entrepreneurial efforts that affect the value. It's all set by supply and demand.
Thank you for that. Sorry, we're out of time. Mr. Chairman, we need to create clear rules of the road here. This technology is the future, and I appreciate anything y'all can do to help create clear rules going forward. Thank you.
The gentleman from Nebraska, Mr. Flood, is now recognized for 5 minutes.
Thank you, Madam Chairwoman. This year, the committee has spent lots of time explaining the deficiencies in Staff Accounting Bulletin 121. Our efforts culminated in passing my resolution under the CRA to repeal the bulletin with support from Majority Leader Chuck Schumer in the Senate before it was eventually vetoed by the Biden-Harris administration. We are now hearing that the SEC's Office of the Chief Accountant is engaging in conversations with some market participants on a case-by-case confidential basis to inform them if they need to comply with SOB 121. It looks like one firm even received a non-objection from the bulletin. It's incredible how big of a hole the SEC has dug itself into. Yet, despite the backtracking and the rebuke from both houses of Congress, earlier today, Chair Gensler indicated he would not rescind SOB 121 in response to a question from my friend across the aisle, Mr. Wiley Nickel. Chair Gensler, now that the Office of the Chief Accountant is picking and choosing who needs to comply with SOB 121, why wouldn't the SEC simply rescind SOB 121 entirely or issue a new guidance?
Stepping back, this guidance, it's the 121st, it's what we've been doing for 52 years, and it's guidance about what happens in bankruptcy, whose assets are there. And crypto bankruptcy after crypto bankruptcy, the bankruptcy courts have said it's not the investors, it's the bankruptcy estate. That's what that accounting bulletin is about. Is it a liability in bankruptcy, basically? And customers get hurt.
Let me reclaim my time, Mr. Chairman. Commissioner Peirce, what kind of signal does it send when the SEC is carving out individual firms from its own staff accounting guidance on an one-off basis? What would be the approach you'd recommend instead of a response to the problems caused by SOB 121?
The approach I'd recommend is we need to go back to the drawing board. We need to figure out what the right accounting is in this area, and we need to do that involving the public in a process, not just putting out a staff bulletin. And then applying it, Chair Gensler mentioned earlier, it applies to public companies, and that's true. It applies on its face to public companies, but we've also applied it to broker-dealers, and now, as you pointed out, we're peeling it back for particular entities. There was a question earlier about why there's only one custodian in the ETP space, and one of the reasons is because of our SAB 121, which makes it very hard for people to be custodians in this space.
And think about the market concentration. There's been no accounting bulletin from the SEC that has ever been as fundamentally flawed as SOB 121, nor has there ever been one that has been considered a rule according to the GAO, and we certainly haven't seen 60 U.S. senators overturn any of the 120 previous accounting bulletins either. Something's amiss here. This does not look right for the SEC. The situation we're in today is indicative of a failure of your organization to recognize just how problematic SOB 121 has been. Chair Gensler, do you believe that SOB 121 has led to concentration risk because of how few entities are able to offer digital asset custody services?
I think it's actually the right accounting. Off-balance sheet accounting is also what, in part, got us into the 2008 crisis. So just remember, like, when people are trying to hide things and put them off balance sheet, it's not good. Also,
you talk about hiding things, Chairman Gensler. We don't even know what deals you're cutting on SOB 121 when you give a no objection letter to a different firm. Like, if we're going to talk about hiding things, let's talk about transparency. Let's talk about how do people in this country operate under our laws when your commission is doing backroom deals with one-off companies and writing them a no objection letter. That's not transparent. That's not in the interest of the American people. You can't follow rules that you don't know about. What's going on?
The accounting bulletin is, the staff accounting bulletin is out, but also for years, companies come in, public companies, and said, this is how we're going to account for something. Do you object? And in this case, if it's remote from bankruptcy, if a company is going to go bankrupt and it's truly the customer's
I'm
fines.
going to hold you there because I want to give your colleague a chance. Commissioner Peirce, I'd like to pose the same question to you. It's market concentration. Is that a risk from SOB 121?
It is a risk, and the accounting raises real questions about whether this is protective of investors or not. And so that's why I think we need to go out with a real process. try to figure this out.
At the end of the day, the SEC has to read the room. And the entire House of Representatives voted on this, and a majority of members of the House rebuked SOB 121, and the Senate, led by the opposing party, they passed it with 60 votes, including the majority leader. This is not a good look for the SEC. This should go away. This is bad policy. With that, I yield back.
Thank you, Mr. Flood. The gentleman from New York, Mr. Lawler, is now recognized for 5 minutes.
Thank you, Madam Chair. Chair Gensler, nearly 3 years ago, the Commission proposed a rule to require the public disclosure of relatively small security-based swap positions, Rule 10b-1. It met significant bipartisan opposition both within this committee and on the Agriculture Committee because of the significant potential for market disruption, undermining of shareholder rights and corporate accountability, and encouragement of dangerous practices like copycatting and herding that the Commission itself has warned about. Given the lack of statutory authority to proceed with such a proposal, its near certainty of being overturned in the courts, and the vast bipartisan opposition, are you willing to confirm, yes or no, that you do not intend to proceed with this harmful proposal that would waste Commission resources and undermine its future authority?
Still considering comments. We do have statutory authority under Dodd-Frank, but there was a lot of, you're right, a lot of comments that said maybe the Commission could collect the information but not make it public. But we're still
So at this time,
considering
you're
comments.
still willing to proceed forward?
We're still considering comments. I'm not prejudging where I would come out or where my fellow commissioners would come out.
Commissioner Peirce?
We heard a lot of feedback, which didn't surprise me, because when we went out, we didn't have the data we needed to go out with that rule. We'll see how the Commission decides to move forward, but I continue to have real concerns about the effect it could have on the market.
Chair Gensler, looking back on your tenure at the SEC, your approach has focused more on quantity than on quality. I think one prime example of my point is that your track record in the courts. I also assume if I asked you about your track record and its impact on the agency, both legally and regarding staff morale, I would get a 5-minute robust defense of your rulemaking decisions. However, I'm reminded of your quote that, quote, "Figures don't lie, but liars sure can figure." And the figures show that the court believes you have overstepped your authority time and again. So let me ask Commissioners Peirce and Ueda their opinions regarding the impact on the agency and staff morale for the courts to consistently rule against the chairman and his hubris.
It certainly isn't good for our agency to be told by courts that we've overstepped the legal authority, and I think it tells us that we need to be more careful because, as you suggest, staff have put a lot of work in on rulemakings that have then gotten thrown out because we didn't have the statutory authority to do them.
These losses to the agency are devastating. I've been with the agency since 2006. In the late 2000s, we lost a series of challenges in court to the Commission's rulemaking. After that, the mantra became never again. We need to be the gold standard in administrative rulemaking. And for a number of years, that is what we pursued, the gold standard in rulemaking. Unfortunately, we've regressed. It is now do what you need to do, that is the minimum required by law. That's why we're doing 30-day comment periods, not because it makes sense to have 60 days, which is what has been ingrained in me that entire 18 years, is you start at 60 days minimum for a comment period. Well, 30 is the minimum days required by law. All of the other steps, let's get it out fast. Let's cut corners where we need to, because that is what is the minimum required by law. But that's like saying a D grade is a passing grade in school.
So in your opinion, the SEC under Chair Gensler is no longer the gold standard?
I've served with 6 chairmen. Unfortunately, our condition today in rulemaking, I would say, is below the average.
I want to follow up on a question from Mr. Sherman earlier, who expressed his concern with Webull and the concerns of having trading apps with Americans' financial data stored in China. I've written 2 letters to Secretary Yellen on Webull and Mumu on this, and the concerns given that Chinese companies are required by Chinese law to share data with the Chinese government, the Chinese Communist Party. So following up on Mr. Sherman's points, how can you ensure these companies are following the law And how can you be confident the information is not available, given that Chinese companies are required by Chinese law to share data with the Chinese government? Commissioner Peirce and Commissioner Ueda.
I mean, I think that the concern that you raise is a legitimate concern. We want to make sure that brokerage customers' information is protected, and it's something that I'm certainly happy to work with you on.
I agree, that is a concern that we have, and with protecting customer information.
Thank you, Mr. Lawler. The gentleman from Iowa, Mr. Nunn, is now recognized for 5 minutes.
Thank you, Madam Chair. Thank you for the commissioners, for the chairman for being here. I'm glad to see so many of you in this room from both sides of the party aisle. Our markets are here to support small business, creating new jobs, farm investments in states like mine in Iowa, and local governments growing pension funds and providing cash for home ownership. Challengingly, under Chairman Gensler's leadership, the Commission hastily and arbitrarily has led to a rulemaking process that undermines the agency's critical mission, making decisions at the expense of small businesses and family farms back home. Chairman Gensler, during your first 30 months in office, there was a 110% increase in proposed rules compared to the previous 2 chairs over the same period of time. Many of those rules are both complex, I think is easy to say. Some of them have been inconsistent, and arguably they've been expansive in scope, and they diverge from the SEC's historical approach to many issues that we've come to depend on. These costs are adding up. $6 billion, an additional $6 million in compliance hours for many of my small businesses and farms. This shouldn't be too surprising when just one rule is 886 pages long. This is a tremendous impact on my constituents back in Iowa. The courts agree with my decision too, because Chairman Gensler, they've taken you to court where you've lost, and then you've lost again, and you've lost again, and again, and again. The courts are piling up in this that you have overreached, and yet you've refused to take advice from me, from Iowans, and we'll hear today from your commissioners. I believe the SEC needs to start choosing Main Street over administrative rule by fiat. So Commissioner Uday, since Chairman Gensler has not answered the request that I have in the letter that we sent to him on June the 13th, signed by many of my colleagues on both sides of the aisle, I'd like to start with you. You've worked at the SEC in various roles for a long time. You know the agency well. You're concerned that the recent wave of legal challenges against the SEC's rulemaking agenda is a threat to its reputation as a well-regarded independent regulator. Would you concur with that statement now?
Yes, I would.
From that, does the overregulation coming from the SEC put not only its reputational brand damage at risk, but cause a harm to the people impacted by it, whether it be a small business, a farm, or others?
Yeah, there are very significant effects, and I worry because of the rapid pace of rulemaking, we haven't fully been able to consider all of those effects, especially where they're negative on small businesses.
And I'll note that you're a Republican commissioner, so I'll turn to a Democratic commissioner. You know, Commissioner Lisgard, around 1% of all venture capital goes to rural startups. Is that correct?
I haven't checked the latest figures, but if that's your understanding, then I'll agree with it for purposes of the discussion.
I appreciate that, and I think that that is actually information I've received from the SEC. Could you point to something briefly during your time that makes it easier for a rural small business to raise capital? Just one of the things maybe that you've done.
I have tried to encourage the small business office to expand its outreach to underserved communities throughout the country, including
I appreciate that, but that's not more than just saying we'd like you to be able to do more, even though we're only giving you less than 1%. Commissioner Peirce, Commissioner Uday, do you have any thoughts on ways that we could reach out to rural communities who need this as well?
Well, I think certainly we could, you know, when I travel, I try to talk to as many people as possible, so that's one thing that we can do. But I think on the rulemaking front, it's exactly what Commissioner Ueda said, which is we need to give people time to think through these rulemakings. You pointed out we've got these very long rules, and a lot of them, and so we need to give people time to think through and give us comments.
I would concur. Commissioner Peirce, I want to speak to you on your public statements. You've urged digital asset firms, whether they be issuers, broker-dealers, trading platforms, to come in and register. Is it currently feasible for an issuer, a broker, dealer, or a trading platform to come in and register with the SEC today?
I mean, realistically, it's not, and I think the evidence is in the fact that we've seen so few firms be able to do it.
I don't want to leave you without the opportunity to respond, Chairman Gensler. And while we've had the opportunity to write you, and I know your team works hard on these things, the fact of the matter is we are Congress, and we do provide guidance for you. I think, in my opinion, you've taken it very far beyond what Congress has provided you information on. In June of this year, we raised concerns and got a surprisingly lackluster response. I'll put that on your staff and your team to hopefully get us back a more formidable answer. I'm concerned that my friends across the aisle, as well as my constituents, your fellow commissioners, all of us are concerned. Most importantly, Iowans are concerned. I hope you take the time to answer for us.
Thank you, Mr. Nunn. The gentlewoman from Texas, Ms. De La Cruz, is now recognized for 5 minutes.
Thank you, Ms. Chairwoman, for holding this hearing today, and thank you to Chair Gensler and to each of the commissioners for being here today. Chair Gensler, I share in the same concerns that many of my colleagues do, and especially what Rep. Nunn has just brought up to the forefront. This process in rulemaking has gone through your leadership, and we're all seeing many, many concerns. Moreover, I'm concerned about your recent proposals that stray further and further from the SEC's own mission, which, as you know, states in part that the SEC should protect investors, quote unquote, maintain fair, orderly, and efficient markets, and facilitate capital formation. That being said, I'm going to turn to Commissioner Ueda. Earlier you said that you have served under how many chairs?
6.
6 chairs. How many years is that total?
Nearly 8, it'll be 18 next month.
18 next month. And so I imagine that you have served under both Republican and Democrat leadership?
That's correct.
And you said, if I wrote here, you said under Chair Gensler, it was below average. Why did you use that word, below average?
For a number of years, I worked on rulemakings. We spent a lot of time preparing, for instance, very detailed summaries of the public comment file. We spent a lot of time and effort on decision trees of all the points that were raised in the comment file, what decisions they would be, what evidence do we have, and what were the course of recommendations. I find today, now, with a little more than 2 years as a commissioner, I see none of that work product being presented to the, or at least for my review in how I think about the decisions that need to be made at the commission level. And in fact, on one early recollection I have when I became a commissioner is I was actually told by the staff, well, we haven't prepared a summary, but you can go read the public comment files on the SEC website, which I found just astounding.
Well, that is obviously very concerning because we need to have all of those details, and just saying go read the public comments is dismissive of your tenure and your experience and the knowledge that you bring to the table. What struck me when you said these words, and they're bold words, is that you say them right in front of basically your boss sitting 3 or 4 chairs away from you.
I'm not his boss.
Well, the chairman of this committee who is making the rules here. And while you might not be the boss and his boss, you are still the leader of the SEC. And it is under your leadership that the rulemaking is coming out. And when you have one of your fellow commissioners just 3 seats away from you with 18 years of experience saying, hey, we have a problem here, that is something to be concerned about, Chairman.
If I might, we have lively disagreements on policy, but the comment summaries that Commissioner Ueda is talking about are actually put out to public, and he also gets those well in advance of a vote. That's what we do, all commissioners get. And sometimes the reason that these things are 800 and 900 pages long is because we summarize all of those comments and pull them into a file that commissioners get.
Reclaiming my
and-
time.
And
Reclaiming
give
my
feedback
time.
on.
And what I would say with that is, this commissioner has 18 years of experience, so it's not his first rodeo to work under you. And it seems to me that he would have the experience to be able to look through those files and through those reports to be able to give substance in a comment. Would you like to comment back to that, Commissioner Ueda?
Well, I know the staff does a lot of work, but it is one where, in my experience as commissioner, I'm getting, at least initially, some very highly summarized documentation as to what's in the common file. Now, it is correct, we do have an extensive amount of discussion in our final rule, but that comes at the very end of the process. You need to make early decisions as to where you might be thinking and where you land. And that occurs, I would say, if not weeks, months before these proposals ever get fully baked.
When I hear what you're saying, I think highly summarized, it means little fact or very vague, and it's
Gentlelady's
difficult to
time.
make a decision with that kind of information. I yield back.
Thank you, Ms. De La Cruz. I now recognize myself for 5 minutes. Thank you to the ranking member, Waters, and to the commissioners for your testimony today. I'm going to start with just some commentary. Chair Gensler, under your leadership, the SEC has become less transparent, less objective, and more political than at any point in recent memory. We need a commission that advocates for more options for investors, not fewer. It's my hope and the hope of many of my colleagues who you've heard from today that we see the SEC cease with its partisan rulemaking and return to its statutory mission as an advocate for investors and our capital markets alike. I'd like to follow up on an exchange with Congressman Rose. The chair and the special purpose broker-dealer's statement was clear. SPBD cannot custody non-security digital assets. Additionally, the proposals to list and trade exchange-traded products could not have been approved as filed if it had been determined that Ether was a security. Commissioner Peirce, as part of a recent settlement, a firm was required to delist the digital assets that the SEC considers securities. The digital assets that remained were Bitcoin, Bitcoin Cash, and Ether. Can you share your concerns with how the SEC and the chair has continued to dance around the classification of Ether?
I think this is the problem with our approach to crypto assets, which is we leave people to read the tea leaves of our enforcement actions. And unfortunately, when looking at what we do, it's very difficult for people to read those tea leaves because we've been pretty inconsistent in how we treat things. And so there's really little for people to rest on. And that's not a good way to regulate.
And is this approach by the SEC serving the public and market participants at all?
It's not serving anyone. It's not even serving ourselves because we're spending so much on enforcement in crypto that we could be saving by just writing rules and then enforcing them against the bad actors.
Or utilizing that for innovation in the market?
Exactly. We could be working with people who are trying to figure out how to use the technology in ways that will be helpful.
And Commissioner Lizarga, do you think this approach is serving investors well?
I do, because it signals to the market that when violations occur and investors are harmed, we are taking the steps necessary to protect them.
In a hearing we had last week, Duke Professor Lee Reiners, who is outspokenly pro-SEC and anti-crypto, said, quote, "There remains a gap in crypto spot market regulation that only Congress can close," end quote. Chair Gensler, why do you insist on trying to close the gap through regulation by enforcement?
We're actually just enforcing the laws that are on the books, and as Commissioner Lizarga said, protecting the public.
Chair Gensler, you've stated that of the 10,000 different cryptocurrencies in the market, the vast majority are securities. If that's the case, does the SEC plan on bringing thousands of enforcement actions in a never-ending game of legal whack-a-mole? Because it sure seems like that's the approach that the SEC is taking.
We don't have those types of resources, but you're right about one thing. There's a lot of non-compliance in this field, and without prejudging anyone, look, if we look at the leading lights 2 years ago in this field, they're either in jail or they're awaiting extradition, some of those leading lights, and there's been tens of billions of dollars of losses out in the communities. Now, that's a worldwide market. Fortunately, it's not all in the U.S.
I'd like to pivot to Commissioner Peirce for a second. So we have this regulation by enforcement. We have whack-a-mole by the SEC in these enforcement actions. And Chair Gensler just mentioned some of these, who he's calling the bad actors that have been in charge. Wouldn't a known structure, a market structure, something that we can actually point to instead of this guessing game among the industry, wouldn't that be a better approach?
It absolutely would be a better approach, and I think one of the things that's frustrated people who are trying to do the right thing is that not only are we playing a game of whack-a-mole on the enforcement side, but the classification of assets, even from our own perspective, seems to be changing over time. And so I've talked to so many people who are trying to build things here, and they don't feel confident, and that's not what we want. We want clear rules, and then we can use enforcement for the bad actors.
And is there a role for Congress to close the gap?
Congress can absolutely come in and tell us what to do and tell us what not to do as well. So I always look forward to hearing from you all.
Thank you. Now we'll go to the gentleman from Tennessee, Mr. Ogles, who's recognized for 5 minutes.
Thank you, Madam Chair. There's an alarming absence of stakeholder input during the rulemaking process. It leads to adverse consequences for market participants. Reviewing individual rules without understanding their interconnected impact is impractical, and it undermines the feedback necessary for rulemaking of this significance. Additionally, the SEC has failed to adequately evaluate the aggregate effects of its proposed disclosure rules on businesses, investors, and the U.S. economy. I urge the SEC to put aside partisan politics and put the American investor first. Mr. Ueda, you recently said in a Fox Business article, and I'll quote, "Regulations should be efficient, effective, and appropriately tailored. Facilitating robust capital markets will also help prevent the need for taxpayer bailouts." These are some common sense goals that President Trump adopted during his first term through an executive order outlining his core principles on regulating the U.S. financial system. Can you please elaborate on that? And also, how do we get back to that gold standard that you mentioned?
The capital markets are one of America's crown jewels. We need to be very methodical and thoughtful as we regulate. We have what I believe are the finest markets in the world right now. Under President Trump, he issued an executive order which set forth his core principles for how we should think about financial regulation, a number of which you just read. After that, those core principles were issued, the Treasury Department, and I was detailed to Treasury as a policy advisor at the time, undertook a wide-ranging evaluation of approaches we could take in a coordinated manner among all financial regulators, banking, capital markets, including the CFTC, even the Department of Labor and their role in insurance, as well as states when it came to, Department of Labor in connection with pensions, and the states when it came to insurance. Treasury issued a series of reports and recommendations and then turned it over to the individual agencies for further consideration. During this time, a broad spectrum of stakeholders were consulted from all aspects of the political spectrum. And that helped formulate a larger global view as to how regulation should occur in a coordinated manner and how we can improve the capital markets and the financial system as a whole. Unfortunately, I've not seen that level of coordination or even foresight and planning in the current administration.
So as we look to the future, and if I'll summarize, you're saying that we need better collaboration amongst the stakeholders so that it can be fully vetted and evaluated by said stakeholders. Also that provides for, you mentioned the 30-day window. It allows a longer period of time for the investor and the markets to adapt and adjust to said recommendations. What concerns me is the idea of the gold standard is gone. Under the current leadership, we've seen an agency go rogue that has overstepped its authority, that has made policies that have been overturned by the courts. We've seen the investor pay the price for activist regulation. Enough is enough. So as we go forward, what are the top priorities? If you were in charge, what would you do right now to fix this?
Well, I think what we need to do is make sure, go back to our core values, which is maintaining fair, orderly, and efficient markets, protecting investors, and facilitating capital formation. Those are all three equally important parts. And I think, to a certain extent, we've been a bit out of balance.
How much time should, the comment period, how long do you think that should be as we go forward?
I think the default should be minimum 60 days, and for more complex and complicated rulemakings, it should be longer. And when we do have different proposals that interact, we should think about reopening comment periods, and we should also think about reproposing proposals when appropriate, because we made certain changes in our thinking.
Well, I would, we only have a few moments left or seconds left, but I would also argue there hasn't been sufficient cost-benefit analysis in these rules, which is why you've seen the courts have to step in, while the markets have reacted as such. Thank you all for being here. I know it's been a long day. With that, Madam Chair, I yield back.
Thank you. I'd like to thank Chair Gensler, Commissioners Crenshaw, Lizarraga, Peirce, Ueda for your testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair. The questions will be forwarded to the witnesses for a response. I ask our witnesses to respond as soon as possible, but no later than October 30th. The hearing is adjourned.